Welcome to the last and final lecture of our 2013 series on democratization and the rule of law. I have the pleasure to introduce our final speaker, the coordinator of the series, Ms. Lorena Pullumbi. She's a visiting scholar and doctoral candidate from the Institute of Advanced Studies in Lucca, Italy. She's going to briefly outline everything that's been said in the previous talks and then talk about her research and where it's going from here. And her talk is basically about EU's role in the democratization of Kosovo. So, no further ado, let's just do this.
Michael. Well, just a brief introduction on our, let's say, the rationale behind organizing a speaker series on democratization and rule of law topics. Basically, we wanted to, let's say, offer a place to people doing research from the academia and also practitioners to look at and inquire, let's say, throughout pieces of original research, topics related to democratization and the rule of law. These are two concepts which are mainly very, very present in the, let's say, academic community lately, especially when dealing with cases like Kosovo, which, let's say, has gone through a process of post-conflict reconstruction to a transition towards establishing a democratic and functioning state. So we are really proud that we actually managed to put together the work of two Fulbright scholars doing research on specific areas related to the rule of law, as Jason Taché and Sandra Jorman. I will later present during the slides, let's say more or less their most important and interesting findings. Also, we have a great honor to have our keynote speaker, Louis having a, let's say, a general presentation on the, let's say, a general approach of the international community vis-a-vis Kosovo, and not only Kosovo, but the region. And also we had Sven Ahmeti's presentation on, let's say, the role of the EU foreign security policy towards Kosovo. Today, my attempt will be not only to wrap up these contributions, but also give, let's say, my own approach and my own, let's say, profile as regards to my research, part of my PhD program. I'm in the second year of my PhD studies, affiliated to this Institute of Advanced Studies in Lucca, Italy. And I've been here conducting some field work and also coordinating the speakers here. So I'll just briefly, let's say, go to the first slide and talk about which are the main, following the presentation of Louis, which are the main patterns of international intervention we have so far seen. And I guess that this is important for us to put it into, let's say, chronological and also critical way of thinking of how the approach of the international community changed towards, let's say, cases like Kosovo, and coming, let's say, to the contemporary presence of the EU in Kosovo. And first, we started through the presentation of Louis and very, very insightful, let's say, reflection on this new doctrine that appeared in the international community called the responsibility to protect. Actually, this was, let's say, a debate going on in the United Nations about the fact that how the international community could gain a mandate in order to be able to intervene in cases of countries which were undergoing, let's say, huge conflicts and preventing, in case they would prevent genocide or war crimes. So this was a discussion that actually went through 2005 in the UN and actually provided for the emergence of this new norm in international right, which is actually also very, very well disputed. Perhaps this is not, let's say, the topic of this presentation, but instead just giving, let's say, a perspective of how the international community reflected and had this lessons learned approach towards its failures and successes in terms of international intervention, humanitarian intervention. So from that doctrine, we then moved to another process of diplomatic mediation. And this is perhaps recalled in the cases of the Dayton peace agreements or also in the Rambouillet talks. Basically, the international community or those coalition of the willings, as Louis was meaning some countries, let's say, being involved in the process of using diplomatic means in mediating conflict, intrastate conflict, such as in the case of Bosnia and in the case of Kosovo. Obviously, also this, let's say, method of intervention or getting engaged also has been really controversial sometimes, and perhaps their results have been quite disputable, as in the case of Bosnia. Many observers are discussing the fact that this diplomatic mediation actually provided for dysfunctional states, as in the case of the bifurcation of power in Bosnia and Herzegovina for the moment. There has been another, let's say, discussion in the international, let's say, overall academic community about these types of new trust issues. So basically involving, let's say, forms of international governance dealing with aspects of reconstructing institutions and the rule of law in countries which have undergone conflict or civil war or unrest. And that's the case for UNMIK, for instance. So these kind of ad hoc interim administrations aimed at having a direct, let's say, stake at state building countries. And from that kind of approach, we have now gone through another, let's say, evolution in the approach of the international community, and we clearly see that in the statement of the EU, and it's encapsulated in this idea of civilian crisis management. So basically, we do, let's say, acknowledge the fact that a crisis exists or there is a potential for a crisis, so we apply civilian, let's say, aspects such as sending judges, prosecutors, legal experts in countries and dealing, let's say, in a shared ownership with local counterparts at developing, let's say, state capabilities. So from this, let's say, general evolution in terms of the international community's thinking, then I just wanted to give you two of the main, let's say, statements present in the foreign policy discourses of the US and the EU. Especially the EU in 2003, during the European Council meeting, launched this European security strategy, which actually was directly mentioning, first of all, the quality of governance, which is, let's say, pivotal or really important to the foundation not only of the EU but also of the other states. So they launched the idea of the best protection of our society. So it starts, let's say, from a kind of security concern, is a world of well-governed democratic states. Spreading good governance, so spreading, I mean, just mention, I've highlighted some of the terms that might actually indicate their approach. Supporting social and political reform, dealing with corruption and abuse of power, establishing the rule of law, and protecting human rights are the best means of strengthening the international order. So let's say this is more or less a general projection of the EU as an international actor in the international arena. And also the US during the, let's say, in the national security strategy in 2006 makes explicit, let's say, reference to the support for democratic movements and institutions in every nation and culture, with the ultimate goal of ending tyranny in our world. Today, the fundamental character of regimes matters as much as the distribution of power amongst them. The goal of our statecraft is to help create a world of democratic, well-governed states that can meet the needs of their citizens and conduct themselves responsibly in an international system. So, let's say, this is just to give you an idea of how important and key importance is given to the quality of government and the rule of law as part of the foreign policy of these two major actors that are also involved in Kosovo currently. So this is here I wanted to invite you just to reflect on what the rule of law actually means. We find that as an appealing, let's say, term in many different writings, policy briefs, papers, rule of law appears to be everywhere. And I wanted to just quote one political scientist who actually has done extensive work on studying the quality of democracy and rule of law. Thomas Carothers says that the rule of law is suddenly everywhere, a venerable part of Western political philosophy, enjoying a new realm is a rising imperative of the era of globalization. Yet, it is sudden elevation as a panacea for all ills of countries in transition should make both patients and prescribers wary. So, I guess that this is a very indicative, let's say, quote, meaning that not only, I mean, we should just focus on the rhetoric, but what does this rhetoric imply in terms of action? Is it really the universal pill that heals all the, let's say, problems of countries in transition, as in the case of Kosovo? Then we will see. In terms of literature, in case you would be interested in studying comparative politics, political science, there has been a huge amount of contribution in the, let's say, prioritizing aspects of the quality of democracy, and rule of law is seen as the prima inter pares, so the first, above all, dimensions of the quality of democracy. In terms of, let's say, a more practical sense, that would, let's say, entail aspects of administrative and institutional capacity to formulate and enforce law, the protection of civil freedoms and fundamental rights, independent judiciary, and let's say, avoiding political interference in the judiciary, fight against corruption, illegality, and abuse of power by state agencies, and a police system that is respectful to the rights of civilian control of security forces. This is a kind of, in case you are, I don't know, willing to write a paper or have a kind of academic reflection on these issues, this is the kind of metrics that I am applying in my own research. So basically, I look at the action and focus on the actor, who's the democracy promoter in this case, might be the US, the EU, the mode of promoting democracy, and also the recipients. So I look at both sides. And in the literature, you can find different references to the kind of promotion of democracy. There are coercive action forms, which actually entail not only, let's say, the intervention through military force, but also using, let's say, direct ownership in, let's say, in the process of building, of state building. And that's, the mode is underlined as instrumental rationality, which means not only a mode of thought, but also of action, of identifying problems and finding a solution for them. And there is another one, which is actually typical, let's say, of the type of democracy promotion process that the EU applies, which is the incentives model. Basically, offering assistance and offering, let's say, rewards, and with the threat of withdrawal and imposing sanctions. This is the conditionality mechanism. For instance, Kosovo, for instance, for the moment has a roadmap for the visa liberalization process, and this is, let's say, a very clear set of tasks that Kosovo has to, let's say, fulfill in order to have this reward or this move forward in the process of visa liberalization. There's also two other types of democracy promotion, which are, let's say, softer or more latent, if we might define them as such. Persuasion through communicative rationality, so having, let's say, an intensive pressure in the media, through civil society, in the public opinion, using the rhetoric of democracy promotion, rule of law, fundamental rights of citizens, citizen participation, and all these things that we are very much aware of. So, just to finish my, let's say, more or less theoretical part, how does this actually, the change occur? So how does actually democracy get promoted in countries such as Kosovo? There is actually a very general temporal process, starting with rule adoption, which means having a constitutional reform, drawing a constitution, a set of laws and regulations, then passing through, let's say, the enforcement of these laws and these regulations through the existence of independent institutions, courts, police, customs. These are the three main areas that ULEX, for instance, is concentrated in Kosovo. And let's say the longer process, meaning rule internalization, which is a longer process defining not only, let's say, the trust that citizens have towards law, but also the rulers or leading elites that must be, aware of the fact that they have to rule through the modality of law. So under this general theoretical framework, we set up a series of topics and sampled main problems that might be sensitive or also indicated through the case of Kosovo. First, Sven was, in his presentation, actually had a very good example of how this copy-paste of legislation method created a fatigue and actually created a lot of problems in terms of implementation because of the fact that there is not a deliberatory process when drafting laws, and there is not a direct, let's say, moment where the representative democracy is actually exercised. There is a problem of principal agent problem as he discussed. So basically, the policy formulation implementation process is jeopardized by the decisions which are actually taken out of the mechanisms of representative democracy. And also this kind of top-down agenda setting model that he also suggested from public policy studies creates a phenomenon which has been described as the democratic disconnect, meaning that institutions are perceived as being beyond, let's say, the democratic control of the institutions, but also the citizens. And this is a huge problem that actually is being discussed even inside the EU, having, let's say, creating this big family of states which have to legislate and create their own body of legislation. And this process is really extremely, let's say, diffused in terms of bureaucratic structures, but also participatory structures. And there is a problem of citizens not feeling that they have a count on the legislative process in the EU. And basically what is being discussed is that the EU is, let's say, exporting its own democratic deficit to countries such as Kosovo, and let's say their own problems are being reflected also in countries like Kosovo. The other sample we took was the constitutional reform. So we are still talking about the case of rule adoption here. The case of Kosovo has a particular, it's an ad hoc, particular constitution based on general power sharing model, giving, let's say, extensive rights to communities, not called minorities, but communities, if it would be correct in Kosovo. A process that, according to Vjosa Osmani, who was a person who took part in the constitutional drafting process, was extremely influenced by dynamics of interest groups, creating this ad hominem effect. So basically the idea that many decisions are decisions to have these arrangements in terms of the division of powers were influenced by the interests of singular individual actors who sometimes were not local but also international. And she brought a lot of evidence on this case. And also another point of our discussion was justice reforms, and we were concentrated on the juvenile justice and the diversion measures, which is supposedly to be one of the, let's say, achievement in terms of adopting legislation in Kosovo through a new code for juvenile justice. Now Kosovo has special court departments in the courts. It has a more child-friendly probation service. It undergoes systematic training for prosecutors and judges to deal with juvenile crime, judges and police also. There is an application and also an increased trust in applying diversion measures, so meaning not residing to indictment, but rather opting for a reintegration method for minors committing offense. But also we spotted out many problems related to the juvenile justice system, Basically, first of all, in terms of read legislation, the statutory clarity of legal provisions, and sometimes cross-referencing between the juvenile justice code and the criminal code, for instance, of the criminal procedure code in Kosovo. A contamination of both common right and civil right terminology, which obviously contributes to much confusion. Also, we spoke about the statutory standard for prosecution to offer diversion, which is an area that actually needs to be improved, and the capacity of community work service, which is still lacking, except the DPN center. And obviously, not only like in the juvenile justice area, but in the whole, let's say, juvenile system in the justice system in Kosovo, there is a huge problem of case backlogs which are not actually being processed and obviously undermining the process of delivering justice. We also had a look at the property law in Kosovo, which is a very, very sensitive issue, really high stakes. Sandra Jorman has done her research in Kosovo, and she argued about unclear and undocumented property ownership, illegal sale and purchase of real estate, illegal construction, and property boundary conflicts, which actually add up more problems to the system, which needs, obviously, we have institutions put in place, independent institutions put in place, which are supposed to enforce the law, but there is a visible enforcement gap, which actually was studied out and willingly will be narrowed. Just to give you a brief introduction of the EU, as I mentioned before, the EU is considering ambitiously itself as a sui generis rule of law promoter, international diplomatic actor which is able to mediate and intervene globally, that is supposed to have a coherent and cohesive external action through crisis management capabilities to deploy civilian and military missions abroad. But obviously, this increasing, the idea is that the stakes are really high, the ambitions are really high, and its international status is being promoted, globally, and so are expectations that the EU would really actually serve as a civilian power globally that can speak with one voice. But this actually raises many issues, as we will see in the case of Kosovo. Here I just wanted to give you some, let's say, numbers to looking at how attractive Kosovo has been so far in terms of international, attracting donor assistance globally. From the period from 1999 to 2007, 3.5 billion euros were poured into Kosovo through projects for state capacity building, rule of law, fighting corruption. Out of these 2/3 were funded by the EU Commission and member states. 608 million euros from 2007 to 2011 were funded by the EU budget. As you will see, in 2008 there was another donor conference with EU and other states which agreed upon allocating 1.2 billion euros to Kosovo. Currently, there are these IPA funds, perhaps you have seen it, basically the instrument for the pre-accession, meaning that through these funds and capacity building projects, Kosovo will be ready to start its own path of European integration. And 92.47 million euros are funded only through IPA projects in the areas of police, justice, customs, and anti-corruption. But the ULEX budget per se actually has diminished from its first stage. In 2008 it was 265 million euros, and now it's down to 111 million euros with the authorized staff of 1,250 international staff and also 1,000 locals. Still, there are a lot of problems with filling these vacancies. These are the authorized, official authorized staff positions, but there are still huge problems with staffing ULEX, especially in the judiciary branch. Here I just wanted, I know that you are more or less very familiar with the performance of ULEX in Kosovo, and you will have your own, let's say, say with regards to its performance. But anyway, I just wanted to give you here, let's say, what international observers are saying. European Board of Auditors and the EU Office for Criminal Intelligence issued a report saying that the situation regarding organized crime in Kosovo has not substantially changed since the conflict in 1999, which is a very, let's say, strong affirmation, given the fact that Kosovo is by far the largest receiver of funds, of EU funds, also in the area of rule of law. There has been many problems related to ineffective investigations of serious crimes, sometimes due to limited experience of judges, perhaps local judges. In Kosovo, according to the procedure for the assignment of judges, there is a criteria for judges having a 12-year experience before starting, let's say, to participate in this mixed panels with ULEX judges in prosecuting serious war crimes or corruption cases. And that would mean that a 12-year experience during this period of, let's say, transition, interim administration, perhaps those judges didn't have a opportunity to exercise their own duties during these years, and they are not trained or not, let's say, updated with best practice in terms of legal procedure. So that causes many problems in the, let's say, micromanagement of the justice system in Kosovo. There is, let's say, an evident problem of an impunity culture which persists in Kosovo, and especially in terms of war crimes, which are, let's say, the most sensitive ones, which need a huge allocation not only of political will, coordination, and also expertise, which has not been done so far. There is a 1,187 backlog of only war crimes, and different instances, court instances have their own backlog of cases, backlog of translations. You just have to imagine that international judges have to get every document translated in English, Albanian, and Serbian, and that all makes the process really slow and makes the system suffer from this huge backlog of cases. As I mentioned before, there is an inadequate state staffing dedicated to the investigation and prosecution of war crimes in relation with the number of cases. So many judges are, let's say, exposed to lots of files, and they don't have the human, let's say, capabilities in processing these cases. There are, in terms of corruption, anti-corruption, there are two independent institutions, which is the Anti-Corruption Agency and the Anti-Corruption Council, and I still didn't manage to find what is actually their specific relevance. It seems that they have overlapping responsibilities and really relatively weak power in investigating and investigating cases of corruption. And so far they have been present, and obviously they are funded by the Kosovo budget, but haven't actually done that much in terms of fighting corruption. And also the problem of the North, which remains a really sensitive issue related not only to the implementation of rule of law, but also to, let's say, higher political stakes in terms of its status. It happens that many local judges, but also international judges and prosecutors cannot actually physically be in the northern part of Mitrovica. Sometimes they have to be escorted by special cars or special forces. Customs officials have to be brought there by helicopter, which actually means a lot of costs for, let's say, making this process be sustainable. And obviously, the ULEX is having, let's say, a stagnant, let's say, perhaps failing result in the north of Kosovo. So these are some of the 1,000 problems. This is a survey done by the UNDP called Public House. Citizens were asked which is their level of satisfaction in terms of institutions, and obviously this is in red. You will find the satisfaction with Kosovo government and political parties. Let's say that perhaps this is also perhaps a euphoric or with high expectations reaction of Kosovo citizens when after the independence of Kosovo, and then we'll see that ULEX has a really quite low level of satisfaction of citizens. This is another index that I usually use when I study these topics. It's the Freedom House Nations in Transit Index, which actually gives a really clear index on a scale from 1 to 7, 1 meaning the highest level of democratic progress and 7 the lowest one, divided in different areas such as electoral process, civil society, independent media, national democratic governance, local democratic governance, judicial framework and judicial independence, corruption, and as you see, Kosovo has, let's say, one of the lowest scores in all of, more or less, all of the indicators in the region. Without wanting to take much more time, I just wanted to have, let's say, going back to this definition of the rule of law and this metaphor that the authors is using by saying that a panacea for all ills of countries, yes, but patients and prescribers should both wear it if it's really possible to actually go from this rhetoric of promoting rule of law to real action, and sometimes there's a huge process in between. So I'll just end it here. Thank you.
Where's your dissertation research going to go?
Sorry?
Where is your dissertation research going to go from here? What did you get out of all of these lectures and interviews and stuff?
I actually am at the beginning of having this field research. I'm trying to have a, let's say, brainstorming approach to the problematic of implementing EU foreign common security policy through nations like ULEX and Kosovo, and trying to identify the problems. Problems are many, and I guess that there is perhaps underestimation of how complicated having a rule of law mission in a country like Kosovo is. And this is projected in many, many problems on a daily basis. So I guess that there is a moment for not only the academic community but also inside of the EU to have a real reflection on what they really want to achieve through this ambition of being a civilian power and launching rule of law mission abroad, which actually are really costly to the EU budget and sometimes don't deliver results. So, yes, Bill.
I was particularly interested in what you had to say about the EU democratic deficit, and it spawned a number of questions, but I'll just ask really one. In an Aristotelian sense, Aristotle said that each society should develop a constitution in accordance with its own values, its culture, history, and so forth. Do you think this EU project, if you want to put it that way, do you think that as a project, maybe the European Union has this wrong to try and impose its notion of what the rule of law and democracy is on a society that may be fundamentally just as democratic, but have different underlying values? The Albanian culture, the Kosovo culture, and the minorities here, the Serbs and so forth, all have different values. And maybe part of the problem is just this attempt to impose this from the top down.
In the case of the EU, I have a different approach. There is supposedly something as a common foreign security policy, a united Europe. And I sincerely and genuinely have doubts on the fact that the EU actually is a single entity. And I see that, let's say, projected in different aspects. And I think that there is not a single approach to what the rule of law actually really means. In terms of organization, bureaucratic, let's say, structure, we use a very complicated bureaucratic machine. And the same goes for its missions, like in the case of Kosovo, there is not a clear chain of command between, let's say, strategic direction from Brussels and operational actions in field. So I guess the whole process is just missing the line of thought of what rule of law actually means. And I do believe that there is a, let's say, a process of exporting these deficits, democratic deficits, abroad in countries like Kosovo, but not only. There were cases where the EU had to act with a single voice, in Libya, for instance, and it was absolutely very difficult to achieve something like that. And perhaps even for obvious reasons, I mean, we have countries that have since decades, 100 years, 1,000 years, had their own approach in terms of foreign policy. Germany, UK, France, they all have their own stance and their own say, and they will actually not see part of their, sovereignty in for an EU project. So still, it's too early to talk, I would say, because the idea of launching, of having our own constitutional, let's say, constitutional framework as the Lisbon Treaty, which actually is not called a constitution, but still, in some matters, it is a young process. Let's say the External Action Service was launched immediately after the Lisbon Treaty was ratified. So it's still a very young process, and I guess that there is much philosophy of learning by doing, rather than having a real clear vision of what we want to achieve. I don't know if I answered your question.
I very much agree with you, actually, although I also disagree in some respects. I agree insofar as I do think that the rule of law project is very much an externally imposed endeavor. Much as there may be nuances in defining who is imposing that project, the reason why I think it is externally imposed and externally foisted upon Kosovo is because the idea of protecting the rule of law, well, creating the rule of law and protecting property rights is really one of the kernels of the post-Washington consensus model of development. So it's really framed within a larger development policy paradigm that kind of essentializes the idea of property rights protection and thinks that it is essential to promote economic development. So much as there may not be a unitary EU actor, that project falls under a larger kind of scheme of things. I disagree with you, Bill, insofar as, I agree also because I think that rule of law promotion is a failed project in Kosovo and in many other transitional and developing countries. But the reason why I think so is not so much cultural. I don't think there's anything inherently anti-democratic or corrupt about Albanian culture, let's say. But rather, I know that's not what you were saying, but I mean, oftentimes there's this kind of idea that lurks in the background when these issues are evaluated. I think rather there's a material basis for why rule of law promotion is not going to stick in Kosovo, and that's because the political economy of the country is inherently factionalist and patrimonial. In the absence of a developed capitalist economy, the best way to make money in a country is to access the state and to funnel state resources away from the public policy purposes, right? And this is the nature of patrimonial politics. You support certain factions, and in return you get material favors. And as I said, in the absence of a developed capitalist economy, the best way to get rich is to enter into this politics of patrimonialism. And that's not going to be put to an end by an external mission that just prosecutes a few corrupt individuals. Because the structural set of incentives is skewed against that mission. I mean, probably the best way to put an end to corruption and patrimonialism is to develop a capitalist economy, but then you're not going to develop a capitalist economy just through a rule of law mission. Much more structural measures are needed. So, in a sense, I see that the basis for the failure of rule of law projects are structural material rather than cultural or political.
There is a very, let's say, present threat of the own internal security of the EU in terms of organized crime, and that's part falling under the mission of the mandate of the ULEX in Kosovo, and it falls under the mandate of many other ESDP missions, EU SDP missions. And that's a real, actually tangible area where you would expect to see results, because the organized crime, obviously we know it's a network, it doesn't pertain to an only country. Corruption also, let's say, drug traffic and all of these things actually do not pertain to an only country, but they are a phenomenon in the region, and the region we're talking about is Balkans, which is the backyard, or some countries are also part of the European Union, so it's just immediately connected to the own interest of the European to preserve its own security. So having, let's say, a real action in tackling organized crime in this area would actually be useful, and not only, this idea of promoting global rule of law, but it's just directly related to the own security of the EU. And I wonder why there is many problems in actually having an action plan in tackling organized crime. When there is huge reports and data are always available there, and let's say the country is relatively small to the capacities of experts who come from Britain, Germany, who are experienced to deal with cases in a bigger context, bigger, let's say, cities, having investigations in cities like London, which is millions of inhabitants, that would be easy, relatively easy in Kosovo. But I guess that there is still a problem of having a political agreement on actually really having an action in rule of law.
Why exactly the EU mission for the rule of law, EULEX in this case, you mentioned in your presentation that it hasn't worked really in the northern part of Mitrovica, but personally I think it hasn't worked in Kosovo in general. So why exactly it didn't work? I mean, based on your research and your knowledge, why did it fail?
I guess EULEX, we have to mention, is a state of mutual mission, so it doesn't take any stand towards the status of Kosovo. But there is, let's say, the EU is engaged in both directions, having a technical status mutual civilian mission in Kosovo, and also having high-rank political mediation between Kosovo and Serbia. And these two dimensions actually frustrate one another. So without having a political settlement and without having a dispute settlement between those former enemies, we cannot actually go through the process of implementing rule of law actions, because judges will be intimidated, lots of violence can occur in the north, and we just cannot actually take a decision on highly sensitive cases without having a political settlement and having a disputed or contested status in Kosovo. It's completely impossible to proceed in these areas. So the EU is basically, perhaps to my own perception, the EU helps to feed the ambition of the EU as identifying itself as a civilian power, but it completely fails to achieve its mission because of this dual-track approach, and not having political settlement, not actually open the way for prosecution of serious crimes, organized crime, corruption, corruption, and all these kinds of issues. So that's it.
Guys, I want to thank everybody for
Thank
coming.
you. Thank you very much.
We're going to have a little reception down the hall, so you're all welcome to come. And congratulations.